Hello students, my name is Liz Attia and today's topic is the law and euthanasia. Okay, so euthanasia and the law. So as we mentioned in last week's lecture, euthanasia actually derives, the term itself derives from a Greek word meaning good death. In terms of a working definition, it is a deliberate intervention undertaken with the express intention of ending a life to relieve intractable suffering. And you'll note there from the definition there that encompasses the different forms of euthanasia that we actually mentioned in the lecture last week. So the voluntary euthanasia, non-voluntary euthanasia, involuntary euthanasia, and then both active and passive euthanasia. So what does the law say in terms of euthanasia within the Australian context? In Australia, it is a crime to take another person's life or to assist another person to commit suicide. It's an offence to assist or encourage another person to commit suicide. And this is set out in Section 31 of the Crimes Act of New South Wales, which is a very dated legislation, as you actually see there. It's in the 1900s. And in the absence of specific legislation, it's unlawful for a healthcare provider to deliberately take the life of another person. What is interesting to actually note here is that the law does make the distinction between letting a person die and taking active steps to facilitate death. And this particular legal distinction and the debate and the issues surrounding that was actually articulated in His Honour's reasoning in the Ardale Trust and Bland case, which is on page 647 of your textbook. And I do direct you to actually go back and have a read of that and notice and take note of the deliberations and the issues that actually the court turned its mind to in assessing what the legal distinction was there between the letting a person die as a natural consequence of the illness or the condition that the person has in deference to active steps that promote death. So traditionally, the courts have not acted in such a way as to allow active measures to end the life of patients. And that's because the courts do recognise the difference between letting a person die and killing them in the hope that Parliament will make legislative change. And why I actually say that is because there is consensus within the legal fraternity that euthanasia is, and laws to permit euthanasia are a reflection of contemporary Australian society and social consensus with respect to the issue. In empirical evidence based on research as recent as, in fact, last year in 2015, where the specific issue of euthanasia was canvassed in Australia, it was something like an overwhelming 82% of Australians actually believed that euthanasia was in fact and should be permitted by law. So although the law does make this, this distinction, it is, I guess, expected or amongst the legal fraternity that legislative changes will eventually catch up to reflecting the views of what is considered by many to be the consensus within Australia. Now, the only other thing that I need to mention here in terms of the law is the Rights of the Terminally Ill Act, which was Northern Territory legislation. It was actually passed in 1995 and it didn't last for very long. It lasted only until 1997 before the Commonwealth Parliament passed Euthanasia Laws Act of 1997, which overturned the Territory Act. The Northern Territory Terminally Ill Act actually made euthanasia permissible. And this was during the time then that Dr. Robert Nitschke, who is featured in your tutorial booklets and some of the cases there, and who remains and was and is an active lobbyist in promoting reform for euthanasia laws in Australia to make it legal. It's during the time in which he actually developed his machine, which sought to be self-directed so that terminally ill patients could actually, through that machine, administer lethal dosage of medication themselves to take their own life. I guess the only thing to be mindful of here in terms of, I guess, the way the law works itself is, although the Rights of the Terminally Ill Act was a territory legislation, so you'll remember from the first law lecture, which was in week 2, we talked about the distinction between Commonwealth and state laws and territory laws, and if there was an inconsistency there, the Commonwealth had the right to actually overturn state legislation, and that's in fact what happened under section 122 of the Constitution. So if the Commonwealth doesn't agree with the territory law, the federal government can pass an act to disallow the Territory Act. And I've got there a clip that I'd like you to go back and watch, which actually talks about the work of Dr. Robert Mitschke and you know, some of his legal provisions that he took into account in actually designing the machine. And we'll have the opportunity to discuss this further and flesh this out in the tutorials for the week. So thank you for your participation. Thank you, students. That brings today's topic to an end.